goes down, you're going to be glad you didn't exercise your option. So it's surprising to me that the state of Texas has essentially prevented investors and tenants from entering into, under their own right to contract, these agreements. But presumably this is designed to protect the tenants. Now, a lot of people have heard about land trusts, and their argument is, I'm going to get around this because I'm going to have the property put into a trust, which means I'm going to deed the property to a trustee, and the trustee is going to hold the title of the property, and then the beneficial interest of the trust is what I'm going to transfer to the buyer. And in that and then we're going to give the buyer the right of occupancy by giving them a lease. So we're just going to have a lease coupled with some kind of an agreement whereby we're going to transfer the personal property interest and the beneficial interest of the trust transfer. In order to understand a trust, you've got to understand the basics. So I'm going to start by telling you a land trust is a device by which real estate is conveyed to a trustee by deed, and then there's an agreement that reserves to the beneficiaries of the trust the full management and control of the property. So the theory is that that's a personal property right, not a real property right. And therefore, we're going to combine a lease with a land trust agreement. We're going to get around the statute because we're clearly not providing the owner or the occupant, I'll just call him, with an option to buy the property, right? We're not giving him an option. We're selling him a personal property. We're not selling him the property. Tell you a little bit about trusts in Texas because it's not well understood. It's a fiduciary relationship in which one person, called the trustee, holds a property interest subject to certain obligations or use that property for the benefit of another. Well, a land trust almost by definition isn't a true trust because it's the beneficiary that has all the rights and control over the use of the property. So it's kind of a fiction. But to start with, a trust is a three-party agreement. It's not a legal entity. We hear people all the time talk about, oh, I'm going to put it in a trust, like it's a legal entity. By the way, I'm having a hard time seeing the clock. What's it say?
5 after 7.
5 after 7, okay. I turn into a pumpkin at 7:30, so. It's a three-party contract, and the three-party contract, because the trust is not a legal entity, it can't sue, and you can't sue a trust. You have to sue the trustee who's holding the property, okay? The three parties, party that puts the property into the name of the trustee is called the settlor, sometimes called the grantor or the trustor. And then the trustee is the party that's holding the title of the property. If you're going to sue a trust, you essentially sue the trustee. And then there's the beneficiary. The trustee is holding this title of the property for the benefit of this third party called a beneficiary. So the settlor transfers record or legal title to the trustee by deed, and it's recorded in the deed records. Now the title looks as though it's in Bryan Dunklin trustee. It's not in the name of Joe Settler, it's in Bryan Dunklin trustee. Then there's a trust agreement between Joe Settler and Bryan Dunklin, and it's not filed of record, but it defines all the rights of the parties. Now, I always like to explain a trust in terms that I think everybody can understand. If you and I didn't trust one another, but we wanted to bet on the Rangers game tonight, and we were at the bar, we might each take our $20 bill and hand it to the bartender. And the bartender's going to hold that $40. Does the $40 belong to him? No. We've created two trusts. He's holding my $20 for my benefit and your benefit, depending upon who wins the bet. And he's holding your $20 for your benefit and my benefit, depending upon who wins the bet. And you know, he might have a little juice in the game. We may agree that he gets to take $1 off the top. But the bartender is the trustee. The bettors are also the beneficiaries, and we're also the settlers of these trusts. Now, what about creditors of the bartender? Can they come in and take his $40 that he's holding? The answer is no. Any more than creditors of the laundry or dry cleaner can come along and take your clothes just because your dry cleaner owes them money. Or it's a little different relationship, but you get the idea. The guy who's fixing your watch can't his creditors can't come and take your watch. He doesn't own your watch. He's just holding it. The IRS, they can't come take the $40 from him. So there are 4 kinds of trusts. One's called a living trust. The fancy Latin words that the lawyers use is called an inter vivos trust. And I use that definition now because you're going to see in the statute we're going to talk about that it becomes relevant. A testamentary trust just means a trust that you create upon your death in your will. And then there's a revocable trust and irrevocable trust, or sometimes called revocable or irrevocable trusts. And they are, as you might expect, a revocable trust is one that the settlor can sort of, hey, he had his fingers crossed, he can take back. And an irrevocable trust is he's put it in the hands of the trustee and he can't get it back. He's given it to the trustee for the benefit of the beneficiaries, and it's done. He can't undo that bell. Again, if you want to find out about these, we've got a trust code. You go to Google, Texas statutes, there's a trust code. You can pull it up. There's very, very little case law on the concept of a land trust. In 1996, a bunch of real estate investors went to Atlanta, and everybody came back raving about the concept of a land trust. And they said, can you tell us if a land trust is legal in Texas? And I said, wait just a minute. And I went to the books. I could find only one law review article by Richard Sales. That was from 1973. He was no longer practicing in Texas. I couldn't find it. And so I started doing the research. I decided I'd become the state's foremost expert on land trusts in Texas. And I wrote an article. And for the longest time, you could Google land trusts in Texas, and my article came to the top of the page. Well, since then, a lot of people are paying for the top spot, so I'm not at the top anymore. But some things have happened, including the executory contract statute, that have made me decide that my client should not be involved in using land trusts. The potential problems. Now, there are some potential opportunities, but typically your transactional lawyers don't want to get involved in uncertainties. Uncertainty is the grist of the mill of a litigator, a trial lawyer, but we business lawyers like to be able to tell our clients what they can expect and be able to stand by that. In the context of a land trust, there's very, very little authority. And the problem that you face is that you're going to be trying to argue that somebody who is in your property, paying you money, acquiring an interest, deducting taxes, building equity, and having the right to sell the property at some point in time and get their equity back out is not buying your property. It's a little bit like saying that this four-legged thing over here on the ground is a table, and trying to convince a court that it's a table, but when the court looks at it, it's got 4 legs and a bottom about the size of your butt, a foot off the ground, and a back on it. They may decide that regardless of the fact that we call it a table, it functions like and looks like and appears to be a chair, and they may decide it's a chair regardless of the fact that you call it a beneficial interest in a personal property right and coupled with a lease. So then the question is, do you want to run the risk of having to give your tenant or your buyer or whoever you're going to call this person that's acquiring this interest all of their money back? And I don't think it's a risk worth taking. But there are a lot of people out there that play the game. I won't ask you to raise your hand, but there are a lot of people who play the game. If you're going to be involved in a land trust, one of the theories is that when you deed the property to the trustee, your ownership interest appears to disappear. Now, you got a separate agreement with the trustee that he's holding that property for your benefit. So it's a self-settled trust, but the agreement is not recorded. Now, the fact that it's not recorded is one of the problems that title companies have in dealing with land trusts. They want to see some evidence of the recorded interest, and here's an interest that's theoretically being conveyed off title, not in the public records. So the deed of the property of the trustee is recorded, but the trust agreement isn't recorded. The trustee typically has all these rights, but I've got one major problem that I'm going to go straight to the bottom line about that I think represents a huge problem in land trusts, and that is, let's see if I can find it here. The beneficiary, whether it's you as the settler or whether it's the buyer, They agree to defend, indemnify, and hold harmless the trustee. And that's a contractual obligation to the trustee. Okay, wow. What does that mean? That means if he gets sued, you're going to step up and defend it, pay his legal fees, and essentially make him whole if he gets sued. And remember, when a trust gets sued, trust doesn't get sued, the trustee gets sued. So by entering into a land trust agreement, you are essentially potentially opening yourselves up to an unlimited check that you may have to write to defend the trustee if he gets sued. I don't think that it's what I'd call a good bet. We also have problems in Texas with self-settled trusts. If you think about it, if all we had to do to keep our creditors at bay was to take our property and give it to a trustee and have the trustee hold that property for our own benefit, life would be rosy, but the world doesn't work that way. I mean, typically if a trust is going to be enforced, it's going to be a genuine transfer to a trustee to hold with some kind of objective standard. You know, when Joe Settlor or Trustor transfers the property to the trustee, and he asks that trustee to hold that property for the benefit of his children, for their health and their education, their welfare, and their maintenance and support, that's a classic trust, one that we're used to thinking about. I'm going to move forward very quickly. These are